As the insider-exclusive investigative news team travels across America producing the Justice in America Network TV series, we invite you to join us as we uncover real stories about the issues that promote justice and fairness for injured people, safeguards victims' rights, and the opportunity to help guide the hands of justice, especially when people's lives have been destroyed, families ruined, dreams lost, or widespread societal change and reform are needed. These true stories about real, ordinary people, their real lives, always up close and personal, and always unfiltered stories of unimaginable pain, suffering, and great wrongs, but also of courage and faith and the dauntlessness of the human spirit. These stories are also about the trial lawyers who helped these ordinary people navigate a very complex legal system to get justice as they faced extreme life-altering adversities, and how the government and big business with their million-dollar PR campaigns are slowly eroding our rights to seek justice and making an end run around the civil justice system. Our TV stories show relief and vindication for shattered lives and seemingly lost souls. The compassion, warmth, love, and determination of the human spirit found within these shows are neither imagined nor contrived. They are truly personal crusades and telling journeys of what it means to seek justice in the American courtroom. In this insider-exclusive network TV special, Justice in America, the Truths and Myths of Tort Reform, we visit with Michael Pitt at Pitt, McGehee, Palmer, and Rivers as he takes us inside today's legal system, examining lawyers' strategies, clients' thoughts, and in vivid detail showing you the often heartbreaking stories of these clients, dramatically demonstrating what motivates trial lawyers to fight for their clients' causes. Some of these same trial lawyers have been in the crosshairs of attacks by so-called tort reform advocates for the past 30 years. These attacks are not new. Now, a lot of you have heard and read about tort reform, but really don't understand how or what it really means, or how it affects us negatively every time we walk into the courtroom. So in this special Network TV Insider exclusive documentary, Justice in America, the Truths and Myths of Tort Reform, we will show you how tort reform is making justice more and more difficult for the average American. And we're not going to do it just by words or fancy language, but by inviting you along to meet our guests in small and big towns across America who've had the unfortunate bad luck to be severely injured or victimized by big businesses, the government, or law enforcement. These victims could be you or me one day, and if you are so unlucky, you will quickly find out that justice in America is a hard-won battle where very few companies and individuals do the right thing. And you need trial lawyers who wage a battle with their own financial resources to get their clients justice. But before we get started, just for the record, let's define what the heck tort reform means in simple language. Tort is a legal term describing the system of compensation used by the courts to assign remedies, awards, and damages for harm done by one party to another, be it to their person, property, or other protected interest. Tort law defines what constitutes a legal injury and establishes liability. It's the civil court's answer to criminal law. Tort reform, then, is the political term for the controversial issue of reducing tort litigation, awards, damages, and/or compensation. Now, tort reform isn't one single idea or law. Instead, it's a group of ideas and laws designed to change the way our civil justice system works. While each tort reform law is different, they all share one or more of the following goals: to make it more difficult for injured people to file a lawsuit, to make it more difficult for injured people to obtain a jury trial, and to put limits on the amount of money injured people receive in a lawsuit. Keep in mind that throughout history, our civil justice system has kept Americans safe by allowing them a fair chance to receive justice when they are injured by the negligence of others, even when it means taking on the most powerful corporations. When corporations and their CEOs act irresponsibly by cutting corners on safety, producing unsafe products, polluting our environment, or swindling their employees and shareholders, the last resort to hold them accountable is in our courts. The legal system provides justice to those injured by deliberate misconduct and deters future misconduct by holding wrongdoers accountable. Michael Pitt, our featured lawyer, has earned the highest respect from citizens and lawyers alike as one of the best trial lawyers in Detroit, in Michigan, and across the nation. Michael Pitt handles complex employment litigation, including nationwide class actions, group actions, and multiple party cases on behalf of employees from the lowest to highest levels of many of the largest companies in the United States. Michael's recent work on the Neal versus Michigan Department of Corrections case, a class action lawsuit filed on behalf of over 500 female prisoners in Michigan who had been sexually assaulted by male prison guards as a part of a team of civil rights lawyers, has garnered him wide acclaim and recognition. Michael was awarded the prestigious National Award of Trial Lawyer of the Year by the Public Justice Foundation in honor of his outstanding contribution to the public interest. The Lawyers for the People Award by the National Lawyers Guild in recognition of extraordinary commitment to uphold human, civil, and constitutional rights. And the Wade Hampton McCree Jr. Award for the advancement of social justice, awarded by the Federal Bar Association. This is the Insider Exclusive, live from Royal Oak, Michigan. It's my great pleasure to introduce Michael Pitt to the show. Welcome to the show, Mike.
Thank you.
Good to see you again.
Good to see you again, sir.
Tell our audience a little bit about your law firm and what type of law your firm practices.
Sure. We're trial attorneys working in the civil justice arena. Our main activity is employment law, civil rights law, and general litigation in the civil justice arena.
Mm-hmm. Today we are here focusing on a concept that a lot of people have heard about but really don't understand what the meaning of it is, and that's called tort reform. Tort reform is a term that was really developed and devised and promoted by the U.S. Chamber of Commerce and big businesses, saying that trial lawyers are bad guys. They file a lot of frivolous lawsuits, and they do this because they want to get rich. It has nothing to do with getting justice for the little guy. What's wrong with that whole concept that big business has been promoting?
Well, for the most part, it's not factual in its orientation. I mean, studies have been performed to show that some of the factual predicates for what we call around here is tort deform.
Right.
And the prevalence of, let's say, runaway juries. The most recent studies show that the median award in a jury case where the plaintiff wins is only like $31,000.
Mm-hmm.
Plaintiffs only win 48% of the time when they actually do go to trial. One of the myths that's been spawning this tort deform movement is the concept of runaway punitive damages. In the cases where punitive damages are awarded, the amount involved is much less than $100,000, and juries only give punitive damage awards in 3% of the cases where the plaintiffs win. So there's a lot of false information developed by the insurance companies and big business, driving the public perception of tort deform.
Right, and they've been pretty successful. I'm looking at some statistics, and this is why we're doing this show, by the way, that about 54% of Americans think that trial lawyers are bad guys, and they're out there just to get rich and file all these ridiculous suits. And annually there is, you've seen this before, the Stella Awards, and it's named after Stella Liebeck, who was the plaintiff in a case against McDonald's. She won, and everybody knows this story, but she won a few $1 million. Later it was reduced somewhat. but it was on some injury that McDonald's Corporation had just ignored for years and years and years, and there had been, I think, 700 other people who have been severely burned and, you know, injured too by their coffee, which they didn't really care about. The reason we are here today is to talk about issues that a lot of people are totally unaware how their rights and their ability to get justice has been taken away, and I'd like to address some of them because you have people that call your office all the time and say basically, I have been wronged, I want justice. Then they start learning about the rules or legislation that's in effect, which makes it more difficult to get justice. Give us some examples.
Well, sure. The most recent trend that we're seeing falls into the category of mandatory arbitration.
Mm-hmm.
Now, how does that work? If you sign up for a cell phone, for instance, you have to sign a contract. Embedded in the fine print of that contract is a arbitration provision.
Which says basically that if you have a problem with your cell phone company, you can't go to court, right?
Exactly right. And this is pre-dispute. So in other words, you're signing up for arbitration before a dispute even arises.
Mm-hmm.
It is based on the company's set of rules about where you can arbitrate your case and how it's to be done. They can require you to go to certain locations to arbitrate your case.
Yeah.
They can put limits on what you can recover. And all of this is given to you as part of the sales package, and you have no choice.
Right.
The only choice you have is either buy the service or not buy the service. And if you want the service, you have to agree to the arbitration. But it goes a little further. Now, 90% of consumer contracts have these mandatory arbitration provisions.
Yeah.
And they completely ban class actions.
Yes. The arbitration.
The arbitration provision in the United States Supreme Court has approved that practice.
Yes.
Which means that if you have 1 million consumers all with a $10 claim, in the old days you would be able to aggregate those claims and make it worthwhile for everybody to pursue justice against the crooked provider of services. Now, if everybody has to bring their own case in arbitration for $10, nobody's going to bring it. So it's a complete denial of access to justice.
And I just want to do the math. $10 times 10 million people, or even 1 million people, is 10 million or $100 million.
$100 million.
Which they got just for free, okay?
Exactly.
And that's what they're banking on. I mean, I hear your math, but I like to bring out the fact that the companies are banking on the fact that nobody can afford to hire a lawyer to pursue a $10 claim.
Well, I did some research.
Yeah.
I wanted to know exactly how frequently do people actually bring arbitrations when we're talking about small amounts. And so what I found was a company called Singular, which was before AT&T bought it.
Right.
There were 10 million customers, and in 2012 there were only 300 arbitrations brought nationwide. With millions and millions and millions of claims, you would think that there'd be more than 300 arbitrations. That's all the records show.
Well, what was the result of those 300?
Well, I mean, it's hard to determine, but I mean, but people aren't able to exercise their legal rights because of the economics involved.
Yeah. Arbitration, in my mind, is what's called private justice. And walk our audience a little bit through. Let's say someone wants to go to arbitration. Is it usually a 3-person panel?
No, it's usually a single
person. That person usually is maybe a retired judge.
Can be, but in certain arenas, such as the financial services arena, they can select industry
So it could be an executive.
It can be a former
Goldman
stockbroker.
Sachs.
It could be somebody involved in the industry. They tend to use people in their industry.
Now, here's where the conflict of interest enters in my mind. Who pays the arbitrator to arbitrate?
The company.
So if I'm hired by AT&T or I'm hired by Singular, and I keep giving awards to the person who's filing a claim against Singular or the people that are paying me, how long do you think I'll have my job?
Not very long.
So there's the conflict of interest right there.
Of course.
Sure, they're supposed to be fair, they're supposed to be just, but the bottom line is if they decide cases more so in favor of the person that's paying them, it's like almost the fox guarding the hen house there, right?
Well, there's some other hidden dangers there.
Tell us about
These are all done in secret.
Yeah.
When you have a court case, everything is public.
Right.
And if you have an outcome in a court proceeding, let's say a product liability case where General Motors is found guilty of this ignition problem that they're having, it's a public record, and you can build on that information to help prove your case. In arbitration, there's no court filing. Everything is in secret. Whatever the outcomes are, you'll never know what they are. And so consumers don't know what is happening with their particular product or their particular service. It's all done in secret, and of course that's exactly what the companies want. They don't want people to know that other people have brought successful claims. That just encourages more claims.
And a lot of the arbitrations are unappealable, right?
You can't absolutely binding. You cannot appeal them, except on some very limited grounds, such as fraud or gross misconduct. Very difficult.
So we talked about cell phones. You handle employment law. You see this more and more in employment contracts, don't you?
It's becoming very prominent now in many large companies where employees, when they sign their application for employment, they're agreeing to an arbitration.
As a lawyer, you're able to overcome some of those arbitration clauses, are you not, if they violate certain civil rights laws, correct?
No, not really. I mean, the courts have said that even in areas like civil rights, arbitration provisions, assuming that they're entered into in accordance with legal standards, are binding. Civil rights cases, harassment, sexual origin discrimination. And
Two weeks.
before they were terminated, and then by the time
Right. You do. As an arbitrator?
As an arbitrator.
Yeah.
That's their choice.
Right.
Right. Into these arrangements.
There is some legislation, it's called the Sunshine in Litigation Act nationally, which would give anyone an option of, after a dispute arises, then they can choose whether they want arbitration or they want to go to court. I don't know. I think that's been pending in Congress for the last couple of years. Hopefully it'll go through. Now, let me ask you, let's say you win an award in arbitration. Is there such thing as a punitive damages award? How do they determine that?
Okay, so just like the class action ban that's embedded in these arbitration agreements,
yes,
many of these arbitration agreements prohibit the arbitrator from awarding punitive damages.
So not only do you have to go into their game room, but then there's a different set of rules.
That's absolutely right. And they can legally restrict your right to make a full recovery of your damages.
Mm-hmm.
So, these are some of the evils that we're dealing with on a daily basis.
Yeah.
It's a major obstacle to full access to justice. The American democracy is based on the concept that everybody should have equal access to the court. The courts are the great leveling of people, and the rich and the poor should be treated just like each other.
Yes.
Tort deform affects certain classes of people, elderly people, housewives,
mm-hmm.
families of dead children are
Mm-hmm.
adversely affected. And how is that? Well, most tort deform legislation has what is called a cap or a limit on emotional distress, pain and suffering type damages.
Right.
So if you have an older person who is no longer working,
mm-hmm.
they're capped on what they can recover. Lawyers work these cases on a contingent fee basis, and if they don't see that a case could generate enough to justify the effort and time and the risk involved, they'll reject the case. And so an elderly person may not find justice because they can't find a lawyer who's willing to work within the cap.
Yeah.
Housewife, not working, no economic damage loss. Her sole claim is emotional distress or pain and suffering, same problem.
Yeah.
Families of dead children. I mean, children don't have earning records. If you lose a child in a car accident or some other type of injury, there's no pain and suffering recoverable, or it's limited anyways in most states now, to ridiculously low levels, like $250,000.
Mm-hmm.
In California, they enacted a cap on pain and suffering damages in the medical malpractice arena at $250,000.
Yeah, 1976.
1976, and there's a proposal today on the ballot, it's going to be in November, to raise it to $1.1 million, finally, after all these years. But, this classes of people in our society,
usually the poor,
your grandparents,
right.
Your wife,
yeah.
Or God forbid, your dead child cannot make a recovery.
Yeah.
And some courts have struck down tort deform for that very reason, saying that it's an equal protection violation, that you pass laws that should not discriminate against one class over another, and that's what they do. And extremely unfair, and most people don't really evaluate the harm of that until it happens to them. And then they come to my office and the light bulb goes off when they're told that you can only make certain types of recoveries.
Yeah.
And they're outraged by it, and they want to know, how did this happen?
Right.
And I tell them it happened because in the 1970s, big business and industry got together and started a propaganda war against victims of injustice and the lawyers who dare to fight for it.
And blaming the trial lawyers.
They blame the trial lawyers. We're greedy. I mean, I have some very interesting statistics about what people think. 83% of all jurors, these are people that actually show up for jury duty, believe that there are too many frivolous lawsuits. 57% believe that lawsuits interfere with the development of safe products. This is the one I really like. 51% of all jurors think that corporations care about safety for the consumers and the public. 51%. We know from General Motors right here in our backyard that this ignition switch problem has been deep sixed for 10 years.
Yeah.
That the Justice Department is now investigating seriously criminal prosecution against people involved in this scandal.
I hope so.
And the jurors still think that 51% of big business cares about safety.
Yeah, yeah.
I mean, the GM case is a case in point, while people are wrong.
Well, this is the reason we're doing this show.
Yeah.
I mean, the facts speak for themselves. We appreciate you taking your time with us today and getting the message out, because we're broadcast all over the place, and this message will get out. And thank you for sharing your time.
Thank you.
Thanks for joining us. You can get more information about our guest and the issues at insiderexclusive.com.